All rise. The Court of Appeal in the 6th District of the State of Florida is now in session. The Honorable James Traver, Chief Judge, presiding. All persons having business before the court solemnly give attention and you will be heard. May God save the United States of America, State of Florida, and this honorable court. Please be seated.
Thank you, Marshal Crawford. Good morning, everybody. Welcome to an oral argument session of the 6th District Court of Appeal. This is streaming live. To the extent that you have not already silenced your cell phones for us, we would be really grateful if you did. My name is Dan Traver. I'll be presiding today. I'm joined by my colleague to my right, your left, the Honorable Carrie Ann Wozniak. To my left, your right, I'm pleased to welcome to our court as an associate judge, the Honorable Logan Murphy. Judge Murphy's day job is in the circuit court in the 13th Judicial Circuit. He sits in Tampa. We have to thank the Chief Justice for what was essentially a pre-COVID discontinued tradition of appellate courts throughout the state, inviting our trial court brethren to sit with us on cases. And we are at a time of need in our court, so we're grateful for Judge Murphy joining us. We have one case on the docket this morning. It is case number 23-446, Petro Welt Trading et al. Versus Edward Brinkman et al. Mr. Lyman, are you going to be arguing?
I'll be arguing on it, Mr. Stoliar.
Oh, okay. I apologize. Okay, Mr. Stoliar, welcome. Typically 5 minutes for rebuttal. Would you like more or less?
5 minutes is fine.
Whenever you're ready.
Good morning, Your Honors. May it please the court. My name is Oleg Stoliar and I represent the appellants. The judgment in this case suffers from multiple due process violations. In an ordinary case, you would only perhaps see at most one. Here you have many, as well as multiple additional legal errors as outlined in the brief. Given the time limitations, I'll focus on just a few of the issues raised in the brief, which are the following. The trial court's failure to rule on a spoliation motion before entering summary judgment, the multiple due process violations, the trial court's improper weighing of evidence, and the multiple disputed issues of fact, which preclude summary judgment. Each of these four issues independently warrants reversal. Collectively, they make it clear that this judgment cannot stand. As to the very first issue, the trial court's failure to rule an appellant's motion for spoliation sanctions before entering summary judgment is a threshold legal error, which, separate and apart from all other issues raised in this appeal, requires reversal.
So, Mr. Stoliar, what's the standard that we're supposed to apply when there is a spoliation motion outstanding? Is it that the trial court always has to decide that motion before deciding summary judgment? Because that's ripe for mischief. That you get filings on the cusp of a hearing, and then you're saying that the trial court has to decide that motion. Is that what you're arguing in this case?
I think what we're arguing, Your Honor, is that in this particular case, it was legal error for the trial court not to.
My question is what the standard is that we should
Well, the
apply.
standard is de novo.
No. I'm sorry. What is the standard of when we should decide spoliation motions when there's a motion for summary
I
judgment?
think the standard is clear unless it is evident that it was filed in bad faith. And here it was filed 3 months before the hearing. It wasn't filed last minute.
But you had evidence of deletion of emails back when the Deloitte report was first issued, right? So you've known for years that there was this issue coming up, right?
Well, we knew there was a potential issue, but we need to take discovery, Your Honor, including the deposition of Edward Brinkman. That deposition was concluded in September 2021, which was the same month that we filed the spoliation motion.
Okay. So again, I asked, so the federal court standard is as a matter of best practice that they should be addressed. But the federal courts have not said that it always needs to be addressed before summary judgment. Isn't there some discretion in the trial court and when they need to address it?
While there may be some discretion, the federal standard also says that if the spoliation motion raises issues where, if granted, it would impact the decision on summary judgment, then the trial court is required to rule on the spoliation motion first. And we cite case law to that effect. I believe the Bernie case.
This is your second district case from the 80s. Have you found any case law in which there is an analysis of the interplay between spoliation, which is a common law concept, and the rules-based notion of Rule 56 or Rule 1.510.
So we did find it's a twofold answer, Your Honor. So first, we did find the case in Florida, Evans versus McCabe, I believe from the Fifth Circuit, a 2017 case that we cited, where the procedural posture and the fact pattern were virtually identical.
I get it. I looked at Evans and there's no discussion at all of where it comes from. So we're a new intermediate appellate court, not bound by any of our fellow district courts precedent. If we're going to issue a decision, which it appears would be binding on the entire state, if we were going to say that there is either, it seems as you're advocating for, an automatic right to have a spoliation motion heard before summary judgment can be disposed of, or potentially maybe the more informed idea that it's best practice or that there's some discretion based on a variety of factors. We're going to be doing this for the first time. So it looks like the limited case law that you cite that talks about the interplay between the summary judgment rule on the federal side and spoliation, the common law concept, effectively invents it. There's nothing in the text of the rule, for example, that discusses it. The first district case that's cited by Birdie and begins with a K, I can't remember the name of the other case, goes back to a King's Bench case from 1722. Predates summary judgment, I think it would be fair to say. So help me understand that interplay and how this opinion writes in your benefit, because I do have some deep reservations about writing a rule that binds the entire state that says that anytime that you file a motion for spoliation, it has to be heard before summary judgment.
So I don't think Your Honors have to make an automatic rule. I think what Your Honors could do on this particular fact pattern is say, given the case law, both the federal case law, which was, by the way, was adopted when 1.380E was amended to make it consistent with the federal rule on spoliation, and the underlying Florida law, and we gave you an example from the Evans versus McCabe case, that when you have a pending motion that was clearly not filed in bad faith, it was filed more than 3 months before the hearing, and where it raises issues that clearly and indisputably impact their relief request and summary judgment, because you have destruction of the same evidence that would prove the claims. And the underlying case law talks about what does the spoliation motion have to show? It have to show that the evidence destroyed was central to the case. So here in the spoliation motion, we did show that there were deleted files that literally had the names of the entities to which the monies are alleged to have been diverted, Edward Brinkman's initials, and the $sign. I mean, an inference doesn't get more clear than that. Moreover, Mr. Brinkman deleted the entire contents of not just his own email account and his mother's email accounts, but the email accounts of the witnesses whose affidavits he relied on with respect to summary judgment. Mr. Harder, Mr. Stroud, and Ms. Meyer. He deleted their email accounts. So as explained, the spoliation motion, destroyed evidence was central to the claim.
So, Mr. Stoliar, I think I understand that argument because you were saying that there are damages in this case. The way that I read the opinion is that the trial court determined that she didn't need to decide that issue because it was, quote, impossible for you to prove damages, whether it's because of an extraterritoriality issue or because of a causation or nexus issue. So I know you didn't bring up damages, but it seems like that is the final, keystone holding the arch together. That is, if there are no damages, how do we decide in your client's favor?
So I think the answer is easy, Your Honor. So there are damages. We explain in the brief why this clear legal error for the judge to conclude there are no damages. First of all, the extraterritoriality issue, that solely pertains to RICO. It's not a required element for any of the common law claims for the damages to take place in U.S. soil. That's not required for unjust enrichment.
I understand that,
So-
but for the purposes of RICO, I mean, what is your extraterritoriality nexus? I mean, we can talk about common law in just a second. I do want to talk about it, but you did bring RICO claims. She did grant summary judgment, and you are seeking reversal on them. So tell me why RICO applies to the damages in this case.
Certainly, twofold. One is you have the Gold TV case. What the judge seems to apply is the bright line case, where if the plaintiff is located outside of the country, you cannot possibly prove domestic injury. And here we had the plaintiff buying goods in the United States, transferring them through Florida, and the plaintiff was deprived of the opportunity to buy the goods at their fair market price.
So this is the X works theory, essentially, that since it was an X works transaction and your clients took title in the United States at a allegedly higher price than should have been paid, that there are damages that are domestic for the purposes of RICO. Is that what you're saying?
It is half of the theory on it.
Okay.
So one is the X works. The second is the Gold TV case says, doesn't even matter if you take title in the transaction.
There was a deprivation of. a
It's
license, and that-
exactly right, Your
But
Honor.
it doesn't seem like that's your theory. It seems like your theory is not deprivation. There's no assertion that I could see anywhere in this case that your client was precluded from buying goods in the United States. I understand that the damages happen in the subsequent markups. That's fair,
I
correct? So going to me, which setting aside the fact that it's an unpublished federal district case, and that you would think that there would be more on this theory out there if it were extant. That seems distinguishable on the grounds that it was a deprivation of a property right, whereas it seems to me you're not arguing that you were deprived of a property right. You're arguing that you were overcharged.
If I could respond, Your Honor. So the Gold TV case doesn't really say you're deprived of property right. It says you're deprived of the opportunity to purchase at a fair market price. That's the damage that you could have bought for $1 million, and instead you had to pay $2 million. And that's exactly what happened here, because you have the centralized purchasing entity, trading house, one of the appellants that is buying. And it was because of the procurement scheme alleged, it was deprived of the opportunity to buy at the real market price. Instead, it was charged double in many cases, or 80% markup. And that's the deprivation. It was deprived of the right.
Yeah,
everyone
certainly
has-
because that deprivation didn't happen initially.
So, well, the system was set up, or it should have been set up, that, I mean, that's the whole point. You had the domestic system and the international procurement system. In the domestic procurement system, they could buy direct. In the international procurement system, they could not buy direct. They were deprived of that opportunity. Instead, they had to go through intermediaries, which were picked by Mr. Brinkman and to some extent his mother, but Mr. Brinkman was the point person.
Were any payments or allegedly inflated markups made in the United States?
Yes, we give examples of that. For example, the WWO 10% markup, which was never disclosed. That was an intermediary in the United States. That was Petra Trading, the Austrian company that Mr. Brinkman was in charge of procurement at that level, as well as other ones. They were purchasing in the US. There were two sets of invoices, right? There was the purchasing order from the US company that nobody saw. And then there was the quote that was provided to trading house. And the quote was always higher. It did not disclose the markups. And one of those markups was a 5 to 10% markup charged by WWO, an intermediary located in the United States. That was directly in the US, direct purchases by Petra Trading in the United States. The first
Ron,
step
in
of
the
the
interest of
transaction.
time, address X works for me, please. It seems to be the stronger of the two theories. However, I didn't see a ton of authority supporting it. So help me with that, please.
Certainly, I believe there was the Baskunin case, among others, given as an example, Your Honor. And that theory is very straightforward. It's undisputed that they took title in the US. As soon as they purchased, they had title. And yet, the goods were not directly delivered. Instead, they were marked up, sent through 5 different locations. And by the time they got them, and sometimes they didn't even get what they ordered, they were paying close to double. And so therefore, you have a clear, in that case, deprivation of a property right, because they took title and they didn't get what they were supposed to get for the price that they were supposed to get. And I do want to return to your original question, Judge Murphy, about damages, because I think it is important because it applies to all claims other than legal claims, Your Honors. That's a clear legal error. What did the judge decide? No damages because it should have been a derivative shareholder claim. That's just wrong on the law. The corporation has the right to bring the claim. The shareholders only get to bring the claim if the corporation refuses. Here, the corporation filed the lawsuit. So this finding by the judge, which underpins the whole denial of damages, is just wrong as a matter of law. They had the right to bring the claim as the corporation at the corporation level for damages to the corporation. And the related argument made by the judge in the opinion on damages that the subsidiaries didn't suffer damages because they passed the profits up to the parent. That's customary practice in any industry. Subsidiaries typically pass profits up to the parents. That does not deprive subsidiaries, which are separate legal entities, of the right to bring legal claims for damages in their own name. Again, I think that's just a very well-established principle of law.
Can I perhaps ask you just a broader question? I know you brought up a lot of topics at the beginning, due process and spoliation. What does the scope of our decision need to be? So I guess a more specific way to ask it is, do we need to get to damages? I know we're talking about that because we're interested in the question, but given the other errors that you've raised, do we need to get there in this particular case?
I don't believe so, Your Honors. I think if you find in our favor on spoliation, that alone is sufficient for reversal. If you find in our favor on the due process violations, of which there are multiple, and I hope I have the time to get into them, if Your Honors want me to, they are each sufficient to require reversal. Due process is a fundamental right. I mean, the case law is multitude that it's by definition harmful error. And here there's no question. I mean,
What's the deprivation of due process as to count 10?
so as to count 10, we're not arguing the due process.
Okay.
We're arguing counts 1 through 9.
So we do have to decide something for count 10 besides due
For
process.
count 10, I think what can be decided is very simple. And we make that argument, the forum non-convenience decision on the eve of trial, because that was really the basis for dismissal of count 10, is just legal error. You don't dismiss on forum non-convenience on the eve of trial.
Well,
Remember-
you brought that in your third amendment complaint that filed a motion to dismiss, and so it's timely before the court, right, under the rules, under 1.061, right?
I'm not arguing it wasn't timely. What I'm arguing is the standard that you apply on forum non-convenience, one of the key factors, judicial efficiency and efficiency for the parties, cost savings. And you don't, that's why after 3 years of litigation, when discovery substantially closed and trial was already set for March, like 2 months later, you don't dismiss on forum non-convenience. Where is the efficiency in that? After 3 years of litigation, then suddenly you have to start all over in a different forum. And moreover, the other factors, and we go into it at length in our opposition to the forum non-convenience, which is part of the record. None of those factors were met. None of the private factors, none of the public factors.
You're into your rebuttal. Do you want to keep going or do you want to reserve?
I do want to reserve, I do want to put one quick point, Your Honor, because I think it's important on just the fraud count, if I could have 1 minute. I think it's important to point out, and I want to read the quote. This is what I was present at the hearing on summary judgment. I heard opposing counsel say, and I quote, that they do not ask for summary judgment on the fraud count because there's so much there that may be questioned, has to go to trial. And then I checked with the court. I said, I just want to make sure I'm on the same page with Your Honor. They said they're no longer seeking summary judgment on count of fraud. So I don't plan to argue fraud before Your Honor unless Your Honor wants. The court's response, that's what they said. That's what I heard too. Close quote. On that record, it'd be, leaving everything else aside, it'd be clear to private due process to rule in their favor after they withdrew the claim and we were deprived of the opportunity to argue it at the hearing. Due process requires notice and opportunity to be heard. Opportunity to be heard, to be meaningful, means the summary judgment context, you get a hearing. You get to argue at the hearing. We didn't get that as to the fraud count. We didn't get that as to the jurisdictional issues, the forum.
I understand the point. Maybe you want to keep the rest of your time.
Yeah, thank you. Thank you.
Good morning. May it
Morning.
please the court. My name is Christy Hatcher-Bolin, and together with Mary Carmen, I represent Najab Development, as well as Edward Brinkman, who has come with us today. We're simply asking this court to affirm.
Let's talk due process.
Sure, go right
Yeah.
ahead.
So and it's really to your credit. I don't think that you spend a lot of time defending the trial court's decision. You do it in the answer brief, but you know, in terms of where your colleague left his argument with granting summary judgment on a withdrawn count, and also granting summary judgment on counts 1 through 9 on bases that you didn't argue below. Is that something, and feel free to defend it. Although, like I said, to your credit, I don't think that you've spent a lot of time doing that. It seemed like your argument was either it's harmless or alternate grounds carry the day. But those due process issues are concerning to me. So I wanted to give you an opportunity to address them.
Sure. I think there was a kind of misspoken, statement. What he actually said is we did not ask for summary judgment on fraud count. That clearly was not the case. We had a summary judgment that was extensively.
I'm sorry, Ms. Hatcher-Bolin, what did he say right after that, though? Didn't he say because there's enough grounds that we think you would deny it?
I think that was also, it came on the heels of the court saying that basically you're running out of time. And so that was it. But as far as the due process, because it's not just a matter of one, I don't think it was withdrawn expressly, especially when you look at the cases they cite, such as TRG, Brickell and Hall and Sorosa. And notice an opportunity to be heard. They not only had notice of it, they filed a brief. They filed 150 exhibits in their compendium of exhibits. And if you look at the allegations of the third amended complaint, the same allegations that undergird their fraud claim are the very same allegations that they talk about throughout their third amended complaint. Every single claim is based, except for count 10, is based upon the procurement scheme. And if you look, and we pointed this out in our answer brief, if you look at the summary judgment hearing, they talked about badges of fraud. They talked about the procurement system. So they had an opportunity not only to extensively brief this, to file 150 exhibits opposing it that dealt with the fraud claim, because again, remember, this is all dealing with the same thing. It's the procurement scheme, but count 1 is fraud, count 2 is conversion, et cetera, et cetera.
But and I understand all of that. You can't be arguing, and maybe you are, and clarify if you are, that if an attorney stands up at a hearing and says, I do not ask for summary judgment on the fraud count because the court, quote, would find that there may be a question that has to go to trial. And then later confirms, yes, Your Honor, I did not argue count 1. Are you arguing that if an attorney stands up at a hearing and says, I'm not arguing that count, that the trial court is still within its discretion to grant summary judgment on that count?
I think in this case where you have notice and an opportunity, and especially where they continued throughout the rest of that hearing, and that hearing was hours.
So I guess
long.
what would he have had to say to withdraw the claim?
I think, I hate to say it, but I think you'd have to use something like a magic word that we are withdrawing that. And by the way, it's not a claim or defense, it's withdrawing.
Aren't you putting the opposing party on the back foot, though? If you're saying things like this, where you're not arguing an issue, and aren't you depriving the other side the opportunity to argue that issue, because you're telegraphing to the entire court and to the other side that you're not arguing that, notwithstanding what happened in the mandatory obligations that they have to file under the summary judgment rule beforehand. If you stand up at trial and say, I think there's enough that summary judgment should be denied, why would the other side put their best foot forward and argue all the issues they need to argue?
I think if you had a case where the other claims were based upon other conduct, I think that would probably hold water. But this is a case where every single claim in counts 1 through 9 were predicated on that procurement scheme. And they argued that throughout the hearing. Every single thing is based upon the procurement scheme. And actually, in some respects, the fraud, even the legal part of the fraud, undergirds the conversion claim.
Okay.
The undue enrichment claim.
I understand
So
that.
It's actually kind of included in all of that.
I understand that. And to Chief Judge Traver's point, I think the other part of the due process is the granting of summary judgment on counts 1 through 9 on grounds that simply were not argued. I mean, that can't be harmless, right?
No,
And it's
no,
not just stepping away. It's granting it on, quote, jurisdictional grounds.
But I think in this case, and especially, I think the judge maybe spoke a little too much. We have a 60-some page order. But if you look at pages 33349 is actually 449 through 58 of her order. That is the meat of this order. And that actually takes each particular count step by step.
So your argument then has to be that even police design hearing is, even though we didn't argue those grounds, and even though she entered summary judgment in our favor on those grounds, ignore that.
I think it is harmless because even if you were to find that she erred on the jurisdiction and that she erred on the form non-convenes, which with respect to counts 1 through 9, because we did raise it in count 10 in the motion to dismiss.
So the only problem with that, Ms. Hatcher-Bolin, is that there's case law that says deprivations of due process cannot be harmless error.
Well, that's okay. No, I would, and I'm sorry. I was actually speaking to the jurisdiction and the form non-convenes. On the due process, I just don't think there is a due process violation because they had a notice and an opportunity.
I'm sorry, but deciding on a question that you didn't raise, jurisdictional and or form non-convenience on counts 1 through 9, that's a deprivation of due process under the governing case law, isn't it?
It is, however, but here's the problem with that. This is why it's harmless. It's almost dicta because again, if we were here, I will give you this. If we were here on a summary judgment that found I'm dismissing it based upon forum non-convenes and the lack of jurisdiction, this would be a totally different appeal. But she didn't do that. She went on in her opinion around page 49 to 58, and she takes each claim in counts 1 through 10, and she meticulously goes through and says why they're not entitled, or while we are entitled to summary judgment. They can't prove their damages. They can't prove that Edward got this money.
So let's talk about that, because a lot of those conclusions that the trial court brought up seem to be based on the Austrian report and discounting of the expert opinions from the appellant. She even used the word expert in quotes, which is concerning, and indicates, that the Austrian report involved more fact finding as opposed to the expert report. So it appears that she weighed the expert report versus the Austrian report, setting aside whether the Austrian report even could have been considered, which we're going to talk about. But how is it not apparent that she didn't weigh that lengthy expert opinion that the appellant submitted against other evidence in the court?
Okay, so I want to take these kind of in two parts. First, the Austrian prosecution report.
Sure.
Okay. If you look at the sites, if you were to go through, and it's tedious, but I actually had to save it as a PDF and search it. And you search for all of the sites to the Austrian prosecution report. Every single one of them is either background information, how the companies were formed, what the relationship was.
I understand that.
And-
I think you did a pretty good job of that in your answer brief in terms of breaking it down. My concern stems from the fact that when you say in that initial footnote, I am going to consider it, you don't know necessarily what that might mean in the context of an untethered, non-cited sentence anywhere else in the order. So I grant you that if you break it down and say when she specifically references it, it may not be as egregious as it seems when you just say, I'm going to consider it and I'll give it appropriate weight. So if you would address my concern that what do we do with all of the other untethered, non-cited sentences that reach factual conclusions that could stem from that?
Well, in that case with the Austrian prosecution report, almost every time she cites it, she also cites things in the record. She cites the Harder and Strata affidavits. Those were actual members of the managing and supervisory boards who were on the boards when they decided to put this procurement scheme in place, which, by the way, is not all that different when they inserted Petro Trading in place of Cat Selling. And there's no allegation, there's no indication whatsoever that Edward Brinkman controlled the procurement scheme when Cat Selling was involved, but it just basically was basically a substitution of Petro Trading because they had complained about Cat Sellings. But every time in her order, when she references the Austrian prosecution report, she backs it up with other things. Our evidence, Harder, Strata, and Meyer, but she also talks about Shabesh's deposition. She also references plaintiff's own exhibits. And by the way, many of their statements came from that Austrian prosecution
So can you
report.
address this sentence? So it's on page 49 of the order. And she's talking about assessing evidence presented by the appellants and says, quote, to the contrary, there have been affirmative findings clearing Anna Brinkman, Walter Hoff, and Edward Brinkman of wrongdoing, referencing the Austrian report. So how is it not that she's not weighing that Austrian report against the evidence that's been presented to create an issue of fact by the appellants?
I'm struggling to find it, but you say page 49. That is basically in the middle of her, I think, her specific rulings
Yes.
on the specific claim.
Yes.
And in that case, I believe she was either dealing with the CRPC claim or the RICO claim. And she was talking about a pattern of criminal activity.
Okay.
That is the only place where she even cites it. As far as that goes, we've got a problem. We've got other problems with their case there because they cannot show.
It's not the
any
only
of this
case she
in
cites.
there.
She cites it on page 27. It says it's uncontroverted that this criminal complaint would be subsequently dismissed by the Austrian prosecutor. And she puts that in bold in her order,
Well,
emphasizing it.
Yes, and that is an undisputed fact.
So
That's-
how is that admissible on summary judgment? How would that be admissible at trial? That conclusion, and I think this is the more important part, perhaps. How would that conclusion by the Austrian prosecutor be admissible at trial? Because the standard under the rule is whether evidence can be presented in a form that would be admissible.
Admissible at trial.
My understanding is that this was never certified. I don't understand that this is a judgment that would be entitled to comedy under the statute. So tell me how it would be admissible at trial in a way that she can consider it.
I think it is very limited. And I think it's very limited to the fact that one of their claims requires an
How about,
ongoing.
I'm sorry, how about just as an evidentiary standard, how would it be admissible at trial? That's all I'm wondering.
Okay. I think it would be limited and only for the purposes of showing, because remember, everything happened overseas and they allege an ongoing criminal enterprise, basically, as part of their RICO claim.
Yeah.
I think that is the only place where it might be admissible, because again, this all happened within the jurisdiction of the Austrian prosecutor. And so whether or not there was an ongoing criminal enterprise would be relevant. And you do have,
Are criminal acquittals admissible in civil cases?
not necessarily,
Necessarily, ever?
I understand.
Okay,
I understand.
so if domestic criminal acquittals are not admissible, and I don't even know the standard that this prosecutor was applying, that's not addressed. So I understand maybe it's admissible for the limited purpose of showing that there was a criminal investigation, but she cites it for the conclusion of the disposition of that prosecution, right? And then weighs that against the opinion provided by the expert?
I don't necessarily think that is the case as far as the weighing of the opinions.
Okay,
I don't, because again, she basically accepts Lester's report, doesn't look at any of ours. You will not see any of our reports cited in her opinion at all. In all those 60 some pages, you will not see that cited. However, she finds that there are things that underlie. I mean, his opinions are a theory of the case. They still have to be supported by admissible evidence. And she finds that they can't connect the dots. They take snippets of transfers from third parties that aren't related to this procurement system that is the foundation of every single one of their claims. Every single one of their claims in counts 1 through 9, the foundation of that is the procurement scheme. Their own corporate representative, Shabesta, confirmed. And if you look in their third amended complaint, the procurement system that was implemented in 2013 to 14 is the basis for their claim for damages. Okay.
Can I ask you about damages for a second? If, say I am operate a solely closely held corporation, and one of my employees steals from me, assume that this is a given fact, and I'm asking you hypothetically. And the theft is sophisticated enough to show that I'm still profitable. But if I hadn't been stolen from, I would be more profitable. Have I been damaged?
The question is, have you shown it? I don't think they've shown that at all.
I was just asking you,
Yeah,
have I
right,
been damaged?
Right.
I've been damaged, right?
Theoretically, yes.
I mean, how could I not be damaged? So the idea is maybe I go from being profitable enough to expand my business to just profitable enough to keep the doors open. Can we concede that that's damage, please?
I can concede that that's damage, but that's not actually what they did here. If you look at Lester's report, and here's the confusing part. They reach back to try to tie these payments to Edward Brinkman before the procurement system was even in place, okay? Because that's the only way they can try to do this, okay? So it doesn't line up with the time, but also you have people that they submitted their statements from, Sokolova, who basically said, I didn't agree with the process, but I had an uninterrupted supply of parts and equipment. And if you look at their own 2014 annual reports, they were making money hand over fist. They were doing much better. And they say in their annual report, it's because of this.
Again,
He doesn't.
I concede that it might not be sympathetic in front of a jury that you're making money one hand over fist as the two hands over fist. However, and I recognize what you're saying. It's hard for me, though, not to read that summary judgment and conclude that as a matter of law, the trial court concluded that you can't be damaged if you're profitable.
Let me kind of continue with Lester to kind of show that. He doesn't show that if we hadn't paid these markups, we would have made this much more money, because you also have to take into account what that procurement process did, that it increased their productivity. So there are so many things that he did not take into account. Basically, what he does is he stops with Trading House, because we know Petro Trading made a profit. Petro Trading, their own director, Elizabeth Meyer, said that basically we made nothing but money. They have no damages whatsoever. We know that Trading House, he stops with Trading House, but what he does not say is that Trading House then sold it as a markup to the subsidiaries. And then what we have in the annual reports is that the subsidiaries have reduced their costs, have expanded their capabilities, and are making more money. So where is the?
So I understand where you're talking about that, but you have an expert opinion and a very detailed opinion saying there was damages, that there were damages, and you may disagree with that. But on summary judgment, is the trial court not in this order discounting that opinion? I mean, that opinion can only be discounted if there is no conceivable manner that that is consistent with the record. And he's taking the evidence, he's laid it out in different records and saying, in my expert opinion, there are damages in this case. Is he not? He says that in the opinion, right?
But his theory still has to be, has to have
Did you-
support in
okay.
inadmissible evidence,
Well,
and that's where
I'm
he's
sorry,
lacking.
wouldn't that be a Daubert motion?
But at the time,
I'm sorry, but wouldn't that be a Daubert motion? If your argument is that that expert opinion doesn't have sufficient support, that would need to be decided on a Daubert motion, not weighing the evidence on summary judgment, right?
well, we did not, at the time, we went ahead with the summary judgment, and
You didn't
yes,
file-
yes, it would be part of a Daubert motion.
Okay,
They were basically, they went forward with summary judgment before the Daubert motions were even.
but that was
scheduled.
your choice to do that, right?
Yes, but
okay.
again, and I think this is kind of the key. She accepted his opinion, but the underlying facts supporting it did not connect the dots. They did not show that Edward controlled every single entity
Hang
involved.
on, so
And they
here-
couldn't show that Edward got any procurement funds.
here's the biggest discrepancy for me. If the trial court in her order said, I am not excluding this opinion, which is what she said, because you objected to it. She said, I'm not excluding it. You have not cross-appealed that. Aren't his opinions admissible?
Well, here's the deal. We don't need to cross appeal if we're arguing an alternative basis to affirm. We would have to cross appeal if we are actually seeking affirmative relief. We're not seeking affirmative
But what you're
relief.
trying to argue to us today is that his opinions have zero weight because they're unsupported by evidence, right?
Yeah, we're saying that he does not have any facts to actually support his opinion, as we've detailed in his brief. Why Gladney? Why
Which
Moskalenko?
necessarily means that that opinion would be inadmissible at trial, right?
Right.
But there's no Daubert motion and the trial court accepted it. So if the trial court accepted those opinions, how can she find there's no damages if he opines as an expert that there are?
Well, she goes further and basically says, and this is actually, I don't know if you say it's further because it's actually part of our argument. You cannot connect the dots. You cannot show that our client got procurement proceeds. What you're doing is you're taking snippets.
Where does she say that?
Well, I said, actually, we said it.
Okay.
Okay.
I don't think she says that.
She does basically say, well, she actually makes a statement that the best you've done is potentially show that Anna Brinkman and Walter Hoff, but you haven't shown any connection to the actual defendants in this case. And we have laid out in our initial brief why what they say shows that there were actually transfers to Edward Brinkman simply don't hold water. They're not, they never actually can show that procurement funds went to Edward Brinkman. And if they can't show that, then their claims are subject to summary judgment. And that was the basic gist of our summary judgment motion. There are no further questions?
Thank you.
Mr. Stoliar, you have 3.5 minutes left.
Thank you, Your Honors. I think the questions were on point, and I think respectfully opposing counsel did not answer them sufficiently to avoid reversal. I do want to bring up a few points on the whether or not and how much weight or import the judge gave to the Austrian prosecutor's decision. All Your Honors have to do is go to page 33311, the appellate record notes 51. The trial court says the factual findings in the Austrian prosecutor's report are well researched and valuable to the court and impact appellant's cause of action. The trial court says it in her own words. She relied improperly on the factual findings, the Austrian prosecutor's report, to reach her decision as to all causes of action. So I think that addresses that squarely. I think also the argument by opposing counsel brought up another issue for reversal, yet another one, multiple disputed issues of fact. They claimed that the board approved various things, but that's disputed facts. The board relied on annual reports. All they say is the total amount spent. They don't identify the markups, much less the excess markups. They certainly don't identify that monies were diverted to Anna Brinkman and to Edward Brinkman. She says that, oh, they didn't connect the dots. The expert connected the dots. The expert traced the monies. The expert issued an expert opinion that monies were diverted from the procurement process to Anna Brinkman's accounts, and then from the same accounts were wired to Majab, Edward Brinkman's company that he founded, owned, and solely managed. And these wire transfers began while Edward Brinkman was still employed by appellant AG. And I think, again, it just goes back to due process. They just fundamentally did not answer Your Honor's question, that it's a fundamental error that by definition requires reversal. And if you find that, you're done. So with that, I would rest unless the court has any questions.
Thank you.
Thank you.
We always appreciate when we get thorough briefing and good argument, and it's happening in abundance here. So thank you both for your presentations. We enjoyed it. We'll take the case under advisement and we'll be in recess.
Thank you.